Appeal and with its history for the now session. The Honorable Mary Ann Wozniak, Judge presiding. All persons having business before the court draw near to the attention to me will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to this session of the 6th District Court of Appeal oral arguments. Just a reminder that we are being broadcast on the internet and recorded. So if everyone could please silence their cell phones, that would be great. Thank you. I want to introduce the rest of my panel. To my, I guess your right, I have Roger Ganem, and to the left, we have Judge Keith White. We have two cases on the docket today, and we will go ahead and get started with the first one. 23-1346, Progressive American Insurance Company versus PCAR Community Healthcare, LLC. Appellant, are you ready to proceed?
Yes, Your Honor.
And how much rebuttal time would you like?
5 minutes, please.
Okay, great.
May it please the court. My name is Michael Clark. I'm here today on behalf of the appellant, Progressive American Insurance Company. We have a de novo issue before the court on the denial of an attorney's fee and interpretation of pure question of law and a proposal for settlement served under 768.79. What we're asking the court to do is reverse that denial and remand with instructions to establish the fee entitlement for a Progressive American Insurance Company. So as I said, the primary issue is the interpretation of the statutory phrase civil action for damages as it exists within 768.79. And PCAR Community Health has filed a breach of contract suit for no fault benefits at the initiation of the action. And since this action was filed, it's always been about the money. That's what the suit was filed for. 2016 breach of contract complaint. A very specific statement that the damages arising for the covered loss were $381.63. So right there in black and white, 4 corners of the complaint, the sole count that was existed at the time the complaint was filed. During the course of the litigation, Progressive served a proposal for settlement. And after that time, after the expiration, indeed, it was 112 days later after the rejection was the first time a motion to amend was filed to add a declaratory judgment action, account for a declaratory judgment. That count became count 1 of the amended complaint, and surviving and proceeding was then count 2, breach of contract complaint. The only substantive difference in count 2 was that they changed the amount in controversy for the covered loss to be $241.07. Again, there it is, all about the money still.
Counsel, can you address the form of the proposal for settlement? Something I'm struggling with is the statute requires the total amount of the proposal to be listed. And here the wording is a bit ambiguous to me. You know, it says at the beginning in subpart D, the total amount of this proposal, more words, is, and then subpart 4, this proposal does not exceed $2 total. Could it be $1? Could it be $1.50, $2? Does that meet the statutory requirements?
Yeah, I saw where there was posed rhetorically those questions in the answer brief, and I would submit the answer is no. Because when you look at page 891, there is, and remember the statute requires specificity to allocate the amounts that would be payable for this case of the personal injury benefits with the sole count that was pending at the time that this was served, as well as the attorney's fee claim. $1 for each of those claims for a total amount of, in paragraph 4, sub D, sub 4, for a total of $2. And in any world, there's no implicit patent ambiguity at all, a latent ambiguity. 1 + 1 = 2. And the word total means the sum of 1 + 1 equaling 2. So that's, I don't think the ambiguity argument is one that is beneficial at all with the wording and the clear statements as required by the statute to make an allocation for both the damage aspect, the monetary damages, as well as the attorney's fee aspect.
What does the phrase "does not exceed" mean?
It is no more than $2.
So you would agree that is different than saying it's $2.
No, I don't agree. I don't know how it could be read like that in terms of an ambiguity. It says what it says and.
Well, I agree with you that it doesn't seem like it's ambiguous. It seems like it's perfectly clear. Does not exceed $2. Does $1 meet that definition?
$1 does not exceed $2.
Does $1.50 also meet that definition?
Well, $1 does not exceed or $1.50 does not exceed $2.
Are you aware of any case that construes that language in the context of 1.442 or the statute? Either way, it is ambiguous, it's not, and even variations that are somewhat similar, like at least, no greater than, any case law that you're aware?
Respectfully, Your Honor, no, I am not. And that's the direct and honest answer to your question. But in the way that this is phrased, in the context of ambiguity, does it affect the offeree's ability to understand what they're going to get if they accept this proposal for settlement? And what they're going to get is $1 for personal injury protection benefits and $1 for attorney's fees and costs in an amount not to exceed $2. And again, I think the word that we need to focus on there is total, because it shows that the language there following directly in order is the simple, and I don't mean to oversimplify it, but 1 + 1 = 2. And I think that is the plain language statement of this, such that the offeree can make an informed decision about accepting it. And that's the key to ambiguity. That's the test. The test is, if there's an ambiguity that would affect the offeree's ability to understand what they would get if they accepted it, the court may find that to be ambiguous.
But does the case law also state that the language of the rule and the statute has to be strictly complied with?
It does. And it's now become very clear that the tail is not supposed to wag the dog. So we're not supposed to be allowing the strict construction, which is applicable to the extent of reading both the rule, or reading the statute, to allow for the Monday morning quarterbacking argument that there was somehow some confusion in the offeree's mind to escape the entire purpose of the statutory scheme. And we've gotten away from the primary points that have been briefed. Ambiguity, of course, is part of it. But what we're seeing in this case is the prototypical example of somebody who, and respectfully, trying to game the system. And that's a phrase that you'll see in Ray Bahario court. If we're going to allow a plaintiff to simply throw in a count for declaratory judgment to frustrate the entire purpose of the statutory scheme, why have the statute? It's difficult to conceive of many of the civil actions that have any relationship to monetary damages, whether it's contract based, whether it is negligence based, to not come up with some way that you could frame a declaratory judgment as well and throw it in there so that you could essentially insulate yourself from the idea that you've taken this, you're proceeding in a lawsuit, oftentimes like the one that we have a history of here with, excuse the phrase, a damn the torpedoes attitude of just going forward. I mean, just continuing and continuing and continuing without there being any prospect of the defendant in that situation to recover their attorney's fees. And it is, this case is probably a textbook example of that. I mean, it's the, PCAR is a two-time loser with their argument initially, no damages. That's what the original judgment, as affirmed at the time by the circuit court sitting in its appellate capacity, said. There's no damages here. This is an application of the deductible. And we may, depending upon how the argument goes, you may hear, well, there was uncertainty in the law because there was an issue moving through the appellate court system at the time as to how the statute, that the no-fault statute should be applied in terms of the deductible. But the facts of this case show that the cumulative amount of the bills that were submitted were always going to be under $1,000. And instead of accepting that simple application of the entire principle of insurance contractual law, they pressed ahead and pressed ahead and pressed ahead until the point where they suffered judgment, the judgment that was infirmed, and then they were able to avoid the consequence of the summary judgment and the affirmed judgment by having a proposal invalidated on the basis of having a declaratory judgment action. And
Mr. Clark, let me ask you about the declaratory judgment count. As I understand, your main argument is it just simply doesn't matter. The offer was made when the case was about damages alone. The offer expired when the case was about damages alone, and the declaratory judgment count came too late. The Palmentary Brothers case out of the first DCA, dealing with this issue in the context of punitive damages. First, let me ask you, is their analysis correct? Do you agree with how they got to the end result in that case, saying that the later amendment to add punitive damages didn't affect the offer that had already been made and expired prior to the punitive damages amendment?
Yes, because I believe their analysis is correct in that, and forgive me because I don't remember if Palmentary used the phrase game the system or make an end run. But essentially what the court was saying was, how can an offeror know to offer a punitive damage amount on a complaint that hasn't pled punitive damages and that expires? And that is directly analogous to what happened here. So I agree with that portion of the reasoning.
The first DCA cited to a couple of Supreme Court cases that I think are relevant. The first one was the Anderson v. Hilton Hotels that simply stands for the proposition that a properly made offer automatically entitles the offerer to fees. If the offer is proper and it expires, it essentially says it's sort of a vested right, or it's perfected at that point in time, period. Do we have to go any farther than that principle? In other words, is that the rule that you're advocating, is that once if the offer is proper and it's made and then it expires, that's the end of the analysis? It doesn't matter what gets added to the complaint as an amendment after that, whether it's monetary, equitable, declaratory, what have you.
I believe that analysis is correct, and I agree with what the court is saying. The one thing that we haven't said is that there has to be the trigger of a final judgment, right? So the offer made expires and then the judgment. So if we add that piece on, I think it's correct. And that's the initial portion of the brief is exactly that. And I will also, because this issue is thrown into the brief about it being in good faith. So there is that portion of this of 768.79 that does allow, if there is a finding that the offer was not made in good faith, that could be a way to avoid the consequence. But Your Honor is correct. Yes.
The trial court in this case did not make any findings on on good faith or bad faith. Is that correct?
That is correct. Yes. Yes.
So if we were to reverse on the grounds that the offer was properly made and expired before the amendment, and so the amendment doesn't matter, can we decide the good faith issue in the first instance, since it was raised, or do we have to send it back to the trial court for a decision on the good faith issue?
I think the court, with it briefed, I think that the idea of good faith can be examined by the court, and I'll tell you why. The reason is because the law is well established there as well, which says so long as there is a good faith basis to make the offer, then it is made in good faith. And that's viewed from the perspective of the offeror. What the offeree thinks in this analysis, or that part of the total analysis, is irrelevant. And in this case, we know what the good faith basis was. The good faith basis was the deductible is $1,000. There hasn't been $1,000 worth of bills submitted to the point that this bill came in. Therefore, we have no liability under this policy. It's going to be completely consumed by the policy deductible. That should be the end of story. So there is the foundation, the good faith basis for making a dollar offer for all about the money that they want, whether it's $261 or whether it's $300, 381. It doesn't matter because it's all about the deductible. So there was a good faith basis. Yes, I think the record is developed enough and the issue has been briefed. I don't think that it would need to be remanded for a determination of whether or not it was made in good faith.
Are you aware of a case that would support that?
Well, and I start with the prospect of, or I'm sorry, the premise of the order says, and for the reasons stated on the record. So I don't recall the trial court saying on the record, I find that it was made in good faith, Your Honor.
She didn't. I
Yeah,
read the
yeah,
transcript.
yeah. But the point of good faith was argued before the court.
It was.
Yes. So to the extent that obviously I think it's preserved. I think it's ripe. And I think the law and the facts are well developed enough for this court to make a decision. If the court disagrees and finds that that is an issue that needs to be determined, we would be happy with that result because the law is going to be in our favor on that point. So either way.
And you're into your rebuttal time. You can.
Okay,
continue to stop.
thank you. Unless the court has any other questions, I will sit down and reserve whatever remaining time.
Thank you.
Thank you, Your Honor.
Morning, may it please the court. My name is Chad Barr. I have the privilege of representing PCAR Community Healthcare in this case. We are asking the court to affirm the trial court's order denying Progressive's motion for attorney's fees pursuant to 768.79. I think both parties did a really good job laying out the arguments in the briefs. I'm prepared to answer whatever questions the court has, but really what I wanted to start by doing is kind of get away from my notes a little bit. And I want to just address the issue that PCAR did this to frustrate the purpose of 768.79. And I think it's important to understand the context with which this case developed. At the time the case was filed, the issue regarding application of the deductible by Progressive was percolating through the appellate courts. And this is back when we had circuit court appeals. The circuit court had ruled on the issue of the PIP deductible. We filed our breach of contract claim thinking very clearly we should win this because they unlawfully applied the PIP deductible as explained by the Ninth Circuit in an appellate order. Once we filed the lawsuit, Progressive then took the position that, well, one, we don't agree with the Ninth Circuit. So they were still litigating the issue of whether the deductible is properly applied or not. But then secondarily, they were saying, well, and also, even if we didn't apply it correctly, it didn't go above the deductible. So now we're sitting here looking at this position of, well, we can prove a breach, but we have this issue of damages. But beyond that, we have a question of who owes the deductible. And the reason why that's important is because if we look strictly at how Progressive applied the deductible to our client's bill, and then also applied it subsequent to Sutherland Chiropractic's bill, what you see is Progressive has actually applied over $1,000 to the PIP deductible. The question is, can PCAR go after the patient for an amount that exceeds the $1,000 PIP deductible? So we have this amount that Progressive admittedly unlawfully reduced, but now they're saying we're going to apply it to the deductible. Now the deductible is over $1,100. We laid that out in the brief. If you need the math, it's in the brief. So now the question is, can we go after the patient for that extra $100? So it then becomes a question of, is the deductible properly applied under the policy, under the statute? And then if Progressive doesn't know it, can we go after the patient? Those are the questions that we have to have answered so that we lawfully pursue our bill. That's understanding that we are seeking a declaration of our rights, duties, and obligations under the policy and under the PIP statute. It's not an attempt to circumvent 768.79. This is an attempt to make sure that we understand what we are allowed to do in this case with respect to collecting that deductible. So
Mr. Barr, assuming that we accept all that at face value, we still have the problem of the deck action being, filed by amendment after the offer was made and it expired. So it's only relevant if that offer, if we're cut off from considering the deck action because it was after the offer expired, then why PCAR filed it really doesn't matter, in the analysis of whether the offer should be, upheld and fees paid to Progressive. So, I'll ask you the same question I asked Mr. Clark. Did the first DCA get its analysis correct in the punitive damages context in the Palmentary Brothers case?
Yeah, it's so different from this case, because in that case, we're not talking about superseding an initial pleading. We're talking about supplementary claim for punitive damages. In this case, the law, it couldn't be more clear. When you file an amended complaint, and by the way, Progressive allowed us to file an amended complaint, not the trial court. And the trial court entered an order, but it was an agreed order because Progressive agreed to the order. It didn't even make us go to a hearing. So we filed a complaint that superseded the original complaint. This is not the first time in Florida jurisprudence that a lawsuit has been amended when there's been a pending proposal for settlement. And so
well, let me ask you this. The first DCA cited a Florida Supreme Court case that says once that offer is properly made and it expires, it's a done deal at that point. The offer has a right to fees if the final judgment that comes out, compares, with the numbers work out, as compared to the offer. So why don't we just stop with that in this case and say, well, once that offer was made and expired, it doesn't matter what gets added to the case by amendment afterwards.
Well, the problem is, even if we get into that level of analysis, the question still has to be answered under Diamond Aircraft, is whether or not it was a general or a specific proposal for settlement in the first place. So if we take the proposal for settlement and we look at it, we didn't have that analysis in that Supreme Court case and in the Palmentary case. We didn't have analysis of the proposal for settlement, but we have that in the Diamond Aircraft case. And in this case, it required, in order to accept, you had to file a dismissal with prejudice, which is a waiver and a release of all claims that could be brought. And that goes beyond just a proposal for settlement specific to the DEC Act or the breach of contract action. So we have a superseding complaint. We have a general proposal for settlement, and all of that under Diamond Aircraft brings us to the conclusion that 768.79 doesn't apply in this case.
But if you don't have the benefit of relation back of the DEC action amendment, then we don't get there, right? Doesn't even getting to Diamond Aircraft depend on that subsequent amended complaint relating back for purposes of evaluating a proposal for settlement?
It's a part of the analysis, and quite frankly, I believe it's a part of the analysis that we can't ignore. We can't ignore the relation back doctrine. So,
well, let me ask you this about the relation back doctrine. I couldn't find a case in the history of relation back in Florida that ever applied it outside the context of the statute of limitations. Are you aware of any case where the relation back doctrine has been applied specifically in the context of an offer of settlement?
No, I mean, this is, it's not a novel issue in the sense that it's never been addressed, because obviously we think it falls under Diamond Aircraft, but I don't think it's been addressed in that specific context to address a proposal for settlement. I think we have to look at each of the specific points of well-established Florida law that says that the amended complaint supersedes the original complaint. Final judgment must be entered on the operative complaint, which is the complaint that superseded the original, and that's what the proposal for settlement has to look at, is the final judgment entered on the amended complaint. And in this case, and I hate that I have to respond to this, but the comment was made that PCAR is a two-time loser. No, we actually won. We just didn't have any damages because the court said, no, Progressive, you did it wrong. We just couldn't prove damages because of the calculation, which obviously we still disagree with, because there's still this issue of how much a deductible is, it can be collected. But this is novel in that specific sense that it hasn't been addressed. Relation back hasn't been addressed as it relates to a proposal for settlement.
Well, and Diamond Aircraft doesn't address the circumstances we have here, in the sense, at the time, all the actions, both the damages action and the equitable relief, were in existence at the time the proposal was made and rejected. Right?
Yeah, that's absolutely correct. I think the issue, though, that we have to look at is, Diamond Aircraft looked at the, I guess there was a question as to whether there was an exception to how 768.79 was to be applied. And of course, so there was no exception, even if the DEC action was, had no merit, was meritless. And so when we're looking at the proposal for settlement statute, we can't build in any exceptions to what's there. We have to follow the law. We have to look at the law, even if we have to piecemeal it together. What we know is that the amended complaint was the operative complaint. The final judgment was entered on the operative complaint. And that's what we have to look at. And I think if we get into, I can't imagine the personal injury cases that we would be dealing with if we looked at this and said, you know, there was an amendment to the complaint, but we're only going to look at the proposal for settlement as it relates to the original complaint. I don't know how that plays out in the long run, and I think it creates more of a mess than what it tries to alleviate. And so in this case, what we know is that under Diamond Aircraft, a proposal for settlement is ineffective to be enforced against a claim for equitable and legal relief, and that's what we have in this case when we look at it on its face.
Mr. Barr, I want to ask if it makes a difference in how we categorize declaratory relief. Is declaratory relief synonymous with equitable relief, or is it something else?
Well, at its root, declaratory judgment is equitable relief. Now, what the third and the fourth PC, I believe, have gone off of is this true relief test, and the true relief test being is the actual issue about money owed by the offering party. And in this case, as I laid out at the beginning, we just need to know if they're going to say that the full amount has to be applied to the deductible, and now the deductible is more than what the patient contracted for, who do we go after for this deductible? And I think that takes it outside of the scope of a question of damages, where, yeah, count one, we think that the claim should have been readjusted. And at the time it should have been readjusted, the deductible, the remainder of the deductible had already been satisfied against Sutherland. So the difference in our amount should have been paid. The trial court disagreed, and so did the PCA. That's put to bed now. But that was the purpose of the deck action. So if we do use the true relief test, what we're looking at is, what questions are we trying to resolve? Is it truly a question about rights, duties, and obligations? And in this case, I don't see how we look at what we asked for in the declaratory judgment action, which I wrote it down. It's in there, but it has nothing to do with the actual payment of benefits. Now, it could have resulted in the payment of benefits. Deck action does allow for supplementary relief. We didn't ask for that in count one. We asked for a determination that Progressive unlawfully applied the PIP deductible, so we could then proceed to determine how we collect on that amount and do so in a lawful manner. I hope does that answer your question, Doug?
Well, I mean, it may be. I'm trying to understand, because a deck action, because the statute seems to contemplate all kinds of relief that may be possible through a deck action. Is the fact that it's called a deck action, does that make it equitable, or should we be focusing on the idea of non-monetary?
Obviously, this court has not had the opportunity to decide whether it's going to apply the true relief test. The true relief test doesn't scare me in this case. If we look at the cases that they rely on, the Di Pompeo case and the Nelson case and the Tower Hill case, those cases all concern the actual payment of benefits. And even in the Tower Hill case, that case concerned the deck action was whether or not the insurance company could unilaterally determine the actual cash value. And I think what's important is the court, in finding that the proposal for settlement statute applied in that case, said that question is part of the breach, question. And so it's assumed in the breach count. And so in this case, how we collect the deductible from the patient when they've applied more than the deductible contracted for is not a question that's assumed within the issue of the breach of contract action.
As I understand your explanation of the deck action, PCAR was concerned with determining how much it could subsequently collect from the injured plaintiff. Is that correct?
That is part of the analysis, yes.
Given that PCAR is here on an assignment of rights from the insured, and I assume that means PCAR can only sort of assert and pursue those particular rights that have been assigned in this case. Would it be proper for any court in this case to determine the rights as between PCAR and the insured, if that was indeed PCAR's goal in bringing the deck action?
I think so, because at the end of the day, they've assigned our rights to enforce the contract, and at the very basic point, that's what the purpose of this action was, to enforce the contract. And part of that is determining whether or not Progressive is complying with statutes and policy. And so, yes, I do think that's, but even if not, I mean, even if we look beyond the assignment, the determination of whether or not Progressive did something that, the question is whether Progressive did something that affects our ability to collect against the insured in a lawful manner. I think is not only appropriate, but an important question for the court to answer in a deck action context. I'm getting short on time, but I wanted to just address the proposal, the substance of the proposal for settlement. The issue really comes down to,
Mr. Barr, let me ask you the same question I asked Mr. Clark. Are you aware of any case that construes this language does not exceed, no greater than, at a minimum of anything like that in this context?
No, not those specific words, but I think we have to look at two things. One, we have to look at the plain language of the statute, which tells them the only thing that they are to put in there is a total amount $2. That's not what they did in this case. They put $1 for benefits, $1 for damage for attorney's fees, and then by adding in not to exceed $2 raises the question of, and we laid these out in our brief, but raises the question, what can be accepted? Can $1 be accepted? And then we go to the trial court on the issue of attorney's fees under 627428. Can PCAR accept $2 and then apportion that $2 however they want to, or does it have to be a portion? $1 to benefits, $1 to attorney's fees. This is what the legislature wanted to avoid when it put the requirement in the statute to just put a total amount. Put a total amount in there. That way we're not looking at multiple numbers, trying to figure out how does this math add up? What's available? What can be accepted? What can't be accepted? No, if they wanted it to be $2, they should have just said total amount of $2. That's it. But what they're trying to do is when they put those, we have to think about this. When they put these amounts in there, like $1 for benefits and $1 for attorney's fees, what they're doing is they're trying to put plaintiffs at odds with their attorneys. And they're trying to say, well, the plaintiff might say, well, I want to take the $1, but the attorney might say, well, but, I got $10,000 in attorney's fees in this case. And so now we're putting the two parties at odds, which, I think goes against not only the law, but also goes against bar rules. And I don't think that the insurance companies should be in a position where they can put people at odds with their attorneys by divvying up the amounts that are set forth in a proposal for settlement. Total amount. In this case, they went a step beyond ambiguity and they said not to exceed $2, but they also went and put in $1 for this and $1 for that, which I think is not in strict compliance with the statute and creates an issue where this court cannot enforce the proposal for settlement.
If I could follow Mr. Barr saying, that's another question I asked Mr. Clark, I'll ask you is, are you aware of any case that would allow us, where the court has not made, the trial court did not make a determination on whether this offer was made in good faith, to make that decision in the first instance, if we accept the other arguments?
Understood. I think we were proceeding under a tipsy coachman argument. Obviously, we made the argument below in our motion, our response to their motion. We made the argument at the trial court hearing. I don't, because it's a question of fact. My gut would almost tell me the trial court has to make that decision first. But I don't have a solid answer for you. I wasn't prepared to answer that. I wish I was, but I don't have a solid answer for that question, other than the fact that it was raised, it was addressed, and we were just proceeding under tipsy coachman. But if it has to be addressed by the trial court, then we would be prepared to do that as well. If you don't have any other questions, I think I've presented all the arguments. And I appreciate your time, and we'd ask the court to affirm. Thank you.
Thank you.
In rebuttal on the point of superseding complaints, I think the rule of law as stated in the State Farm versus Tippett case in the answer brief is as it relates to superseding in the relation back doctrine. If the amended complaint would supersede the original complaint to the extent that you would no longer be concerned with the preceding pleading, unless there is an intent to preserve portions of the earlier pleading. So I would submit that under State Farm versus Tibbet, we still have to look at the breach of contract count remaining. In rebuttal to the idea that this was a general offer that would have also required them to voluntarily dismiss their deck action at the time. Obviously, that's impossible because the deck action hadn't been filed by the time it had been, by the time the proposal expired. As to the idea that they were seeking a declaration of rights as to whether or not they could collect against the insured. I looked at the declaration. It's not apparent there is a request, and I understand that this is a pleading standard, but I did not see as we were going through this procedure any statement to that effect in the pleading itself. But more importantly, the assignment is the idea. PCAR only takes the rights that the insured has, and PCAR is not going to essentially collect against itself. And I think that the final point, which is what has been discussed, is that at the time of the expiration, that's when the vested right to make this claim for attorney's fees on the proposal for settlement exists. And we would ask that the court reverse and remand with instructions to have entitlement for Progressive's attorney's fee under the proposal for settlement. Thank you, Your Honor.
Thank you very much. It's well argued on both sides, and we appreciate that. Do you all need a break? You need a break? Or?
It's up to you.
Okay, I'm good.
Okay.
Okay. We're gonna, what's that? You may be excused, sorry. We're gonna move on to the next case, so let's switch out. The next case is 23-1433 Mayfield versus Zaxby's Franchising LLC and Fixin' Chicken LLC. Are you ready to proceed, counsel, on both sides?
Yes,
Okay.
Your Honor.
And you may proceed. Oh, before you start, rebuttal time. How much would you like?
5 minutes, please.
Okay, great. Thank you.
Thank you, Your Honor. May it please the court, Blair Fazio, on behalf of the appellant Tamala Mayfield. Thank you for allowing us the opportunity to present our arguments here in person. We are here today because the trial court erred in granting final summary judgment based without regard to an allegation alleged in Tamala Mayfield's complaint based on the improper flooring surface. As alleged, Zaxby's owed a duty to appellant to provide, maintain, and install a proper and safe flooring surface. Here, they did not do so. In moving for summary judgment, Zaxby's made no allegation, argument, response that it owed no duty to the public to provide a reasonably safe flooring surface, and it did not argue that Tamala Mayfield didn't produce sufficient evidence to present her case to a trier of fact. Instead, Zaxby's argued a case based on the transitory foreign substance statute and said that liability couldn't be imputed under an agency theory that wasn't present in Tamala Mayfield's complaint. In granting summary judgment, the trial court did not give regard to Tamala Mayfield's allegation, and therefore summary judgment must be reversed.
Counsel, doesn't paragraph 14 of count 3 specifically allege that Zaxby's buying through its agents and employees, et cetera? I mean, doesn't that raise the agency issue?
Your Honor, that language, and as we briefed it, that language explains that an entity needs to act some way. An entity doesn't act by an LLC. It's a legal term of art that is in all complaints. We didn't argue that a vicarious liability claim, for example, saying that Zaxby's is negligent because Fixin' Chicken installed an improper flooring surface. We didn't allege that Zaxby's was negligent somehow because Fixin' knew or should have known that the floor was unsafe. What we're alleging is a direct and independent cause of action against Zaxby's for the selection of the improper flooring surface, which goes unrefuted. It's very clear. The case is clear. Like, Zaxby's got up and didn't refute our expert affidavit saying that the floor was slippery. And in fact, at summary judgment, the trial court said, what about the expert affidavit? Zaxby said, well, that goes to the slipperiness of the floor. So again, the focus is not on agency and independent contractor and imputation of liability. What the case is about is a direct negligence case against Zaxby's. They had a duty.
But counsel, in paragraph 14 and 15, you also use the terms, and I understand your argument about construct and install. I'll have different questions for that. But in the paragraphs, it also uses the term maintain, keep, maintain, and provide. That seems to me operational, day-to-day sort of language. And 16 is even more explicit, it seems to me. Defendant keeps records, and this is referring to Zaxby's, keeps records of each slip and fall, purchases slippery when wet warning signs, trains all of their employees. How is that not? That makes no sense in the context of a franchisor unless you're saying the operator's employees are also the franchisor's employees through an agency. I mean, as best as do you think that's a reasonable reading of those allegations?
Well, Your Honor, if I may go back to I know you had a lot of questions in there, so I just want to make sure that I address all of your concerns. So at first, your first question, or your sub question rather, was that whether there was an ongoing, or whether that language should be interpreted as like a day-to-day ongoing maintenance. What we're saying there, and the interpretation that could be possible, maybe that's possible, but what we're saying is that Zaxby's had an ongoing duty because it is clear from their licensing agreement with Fixin that Fixin didn't have a right to change the flooring. The licensing agreement states that Fixin Chicken had to select the flooring from an approved list of building materials. It also says that Fixin Chicken had to construct and maintain the premises in a way and in accordance to Zaxby's specifications. Fixin couldn't go in there and say, hey, I'm going to maintain this floor by adding an adhesive. Or, hey, I see that this Restec flooring that Zaxby's mandates we install in our kitchen because it's more slip resistant should also be placed in our dining room for the general public. It says the licensing agreement that presumably Zaxby's itself drafted mandates and that Zaxby's retains the control over the day-to-day flooring.
So Fazio, let me ask you, because I think this really goes to the kind of the fundamental question of duty. The complaint talks about provide, install, and maintain the flooring. But as I understand the evidence in this case, and I think you've just argued, what Zaxby's, the franchisor, did was specify what flooring to use. But that's where their involvement in the flooring stops. So don't we have to look at the duty owed and then eventually look at causation based solely on Zaxby's specification of what floor should be installed in the restaurant? I mean, do you agree that it's their specification of the flooring that's at issue as far as their potential liability, and not how the flooring was maintained or installed or anything like that?
Well, if I understand your question correct, of course, what we're saying is that they're negligent because they chose a floor, they required a flooring that was unsafe. Okay. The maintenance, right, agree. The maintenance part doesn't come in, and I think, Judge White, I think your question's more like, we're not saying that they had any imputation of liability to mop at certain times. What we're saying is the maintenance of it is the very fact that Fixin doesn't have a right in and of itself to change, modify, add, or do anything to this flooring that Zaxby's itself chose from an approved list of building materials.
Is your position then that Zaxby's, the franchisor's negligence was in selecting a flooring surface that, according to your expert affidavit, had a traction rating of 0.45? In other words, it didn't have a traction rating of 0.45, which is the standard. It only tested it at 0.41. Do I understand that correctly?
Correct, Your
Is
Honor.
that the negligence of Zaxby's, the franchisor, that's at issue in your claims against Zaxby's?
Correct, Your Honor.
And so if that's the case, then when I read this expert affidavit, the concluding sentence in paragraph 11 is, all the circumstances mentioned in the foregoing findings produced or contributed in whole or in part to the incident experienced by Ms. Mayfield. But all those circumstances mentioned in the foregoing includes not only the flooring that was tested to be substandard according to the tester, but also includes statements about how the non-slipperiness of the floor was not even because there was a substance on it. And it cites to Ms. Mayfield's testimony. So both the substance on the floor and the flooring surface itself are mentioned in the expert report. And the expert says all of that contributed. So my question is, how do we know, how could a finder of fact infer that it was the flooring surface and not the substance on the flooring surface that was the proximate cause of Ms. Mayfield's fall?
Your Honor, the expert affidavit, going back to it, says that all of the foregoing caused in whole or in part, or contributed, cause, or in whole or in part. And I want to go back to what you're saying. We're recognizing that Tamala Mayfield produced this affidavit in response to a motion for summary judgment that doesn't even address this cause of action. So again, Zaxby's never disputed that this is at issue, is your question. What they said is that Tamala Mayfield can't proceed to trial because of the transitory foreign substance statute. They're not saying, Zaxby's never made that argument below. What their argument is that liability can't be imputed for the failure of Fixin' Chicken to notice that there was a transitory foreign substance stat on the floor. So we just want to remind the court that our right to proceed to trial was based on something that wasn't alleged in our complaint without regard. And we know that that can't be possible. To answer your question substantively, that is an issue of fact that needs to be presented to the jury. That is an argument that Zaxby's should present to the jury as to whether it was their flooring, it was the substance itself, or a combination. But joint responsibility and joint liability doesn't relieve the original tortfeasor of a right and of a duty to its customers.
Is it important in terms of understanding how the friction rating of the floor, whether it's 0.45 or 0.41, isn't it important to understand how that flooring surface interacts with the particular substance that the plaintiff slipped on? And I'll give you an example. Suppose that motor oil is slippery on a floor with a rating of 0.45 or a rating of 0.41, such that the flooring doesn't matter. If someone steps in motor oil, they're going to slip regardless of the flooring surface. But on the other hand, suppose that salad dressing is less slippery on a 0.45 rated floor than it is on a 0.41 rated floor, such that, well, it was not only the substance, but also the flooring itself that contributed to a slip. I mean, if those things are true, and I understand that those are hypothetical and it's not in the record, but don't we have to know something about the substance involved to understand whether the floor had anything to do with it?
Well, we do from this expert affidavit, which is also unrefuted. Zaxby's never produced another expert affidavit that conflicts with these findings. They didn't take the deposition testimony of our expert witness. They didn't even address all of your hypotheticals at summary judgment. Again,
But so could a reasonable jury infer from the expert's report, not only that the testing done 5 years later, that not only infer that the flooring was in the same condition 5 years prior, but also that it didn't matter what the substance was because the flooring was substandard. In other words, can the jury really infer that it was the flooring without knowing what it was that Miss Mayfield slipped on? Because we don't know that, correct?
well, we know that it was a slippery and greasy condition. And we know that Zaxby's is a fast food fried chicken restaurant. We know that the area, and I'm going to quote here, where Miss Mayfield slipped and located within the seating area was a fast food restaurant where patrons independently carry trays of fast food and drinks from the service counter, and where from patrons independently carry trays of fast food and drinks to the trash receptacle.
But what if it was sunscreen and had nothing to do with a food substance? Would our analysis still be the same?
I believe so. Yes, Your Honor. It's the duty of care owed by Zaxby's to provide a reasonably safe flooring surface. We know, right, that industry standards say that this floor fell below industry standards. We know.
Where is that in the affidavit? I see a statement here that says all areas tested. This is in the block in paragraph 9. Says deficiencies noted, all areas tested fell below the high traction rating of 0.45 or above that would be desired. Desired by who?
Well,
I mean, to me, for negligence, doesn't it have to be required to be a legal duty? I mean, where's this 0.45 coming from? That wasn't clear to me in the affidavit.
Okay. Your Honor, we're getting this from, it does say here, right under the flooring, Miss Mayfield slipped on, fell below the minimum traction rating for flooring in a public dining room.
Where are you reading? I'm sorry.
Right under the box that you just read from. It's right above paragraph 10. If I.
Oh, okay, but where's that coming from? I mean, that's a legal issue. An expert can't opine on what the law is if that's what that is trying to be.
Well, an expert can opine or given a conclusion as to whether as to industry standards and duty. We know that. And that's what this expert affidavit is. Again, Zaxby's had an obligation to provide.
I'm sorry, but where does it say that where does this tie into an industry standard?
Well, the industry standard comes from the fact that when the coefficient of friction test comes below a certain level, it violates a number of statutes, regulations, ordinances. This includes the National Fire Protection Act, the American Society for Testing and Materials, which is the ASTM standard.
But where are you getting that? Where does it say that, for example,
Right.
the ASTM standard for traction rating, the minimum ASTM for flooring is X? Where is that?
That's in paragraph 7. It says both the NFPA 101 and the ASTM F1637 state that walkways shall be slip resistant. Do you want me to?
I see that, yes,
Okay.
slip resistant, but that doesn't
mhm.
have a coefficient of friction attached to it.
It doesn't, and I could read the entire affidavit over, and the affidavit may not be specific that each sentence ties in the way that it seems like you would like it. But again, that was for Zaxby's to refute. Zaxby's chose not to dispute that this expert affidavit requires a standard of care. They didn't get up there in summary judgment and say, hey, this affidavit doesn't say enough, or hey, this doesn't provide for the duty of care. What they did instead was just solely focus on the transitory foreign substance statute and say, hey, liability can't be imputed on us because our own contract that we drafted says that Fix and Chicken is an independent contractor. So you know, it's not our fault that that Fixin' Chicken didn't see, know, or should have known of this transitory foreign substance. That's what they said. On summary judgment procedurally, they sat back and said, hey, we're taking no position. So procedurally, there's a procedural bar here. They can't now say, and their brief spends a lot of time saying, hey, it was really the transitory foreign substance. It wasn't us. But they can't do that. They can't have it both ways. They had an obligation to either object at summary judgment or stand mute, and they did nothing. I think that the quote was, we're just here to observe at summary judgment. Now, all of a sudden, they're saying, oh, wait, it was really Fixin', but Fixin' now has a legal determination that they're not at fault. So they can't now say, hey, it wasn't us, it was Fixin' Chicken. So to your point, all of these factual disputes that are created from our expert affidavit are just that, if any, are factual disputes that Zaxby's failed to raise below. So right now, presently before this court, we have an undisputed and unrefuted expert affidavit, which provides for a duty of care that was breached, and we have causation and damages. We have no argument whatsoever from Zaxby's to refute this claim, and therefore
well into your
summary
rebuttal time.
judgment should be reversed. Thank you, Your Honor.
May it please the court, Carla Sabah from the law firm of Rywant, Alvarez, Jones, Russo, and Guyton on behalf of Zaxby's Franchising LLC.
I'm sorry, counsel, could you pronounce and spell your last name again for me?
Sabah, S-A-B-B-A-G-H, Your Honor.
S-A-B-B-A,
G-H,
and it's pronounced Sabah.
Sabah.
Thank you.
Your Honors, I had an entire argument planned. However, I think it would probably be best if I simply went ahead and addressed some of the issues that were discussed with my colleague. One of the issues that I believe was raised by Judge White, and I think is very, very important to the entire consideration, is this. In the complaint, it was a multi-count complaint, two of which related to my client Zaxby's. Count one was specifically with regard to civil negligence, and count three was with regard to the improper flooring. The appellant's brief waxes poetic about the issue of count three, that the summary judgment order was entered with regard to issues that were not contained solely within count three and were not effectively what was pled by the plaintiff. However, if we do take a look at the complaint that was filed by the plaintiff, that is located on pages 53 through 60 of the record on appeal, paragraph 7 very specifically states that plaintiff Tamala Mayfield slipped and fell on a slippery liquid substance which had accumulated on the floor, thereby sustaining injury. If we look at count three very specifically includes and incorporates paragraph 7. So count three includes this allegation that she slipped and fell on a slippery substance. To the extent that there is any argument that should have been excluded, precluded, or not considered by the court in its analysis of count three, that would simply be incorrect. It is pled, it is included in count three. In paragraphs 14 and 15, there is that allegation that Zaxby's, by and through its agents and employees, thereby raising the agency issue, needed to construct, maintain, and keep the aforementioned premises reasonably safe. These are ongoing duties as pled. Present tense, to construct, maintain, and keep the aforementioned premises. That certainly suggests that there is an ongoing duty to construct or change the flooring as needed, maintain and keep the premises safe. Again, there is a franchise agreement which was very clear on who that ongoing duty belonged to, and it was not the franchisor. In addition,
But counsel, and I understand your argument. That's why I asked the questions of Ms. Fazio, but I'll ask you.
Yes, Your
As
Honor.
I understand Ms. Fazio's argument in response to my questions, that at least in part, there are portions, there are allegations in count three that relate to a direct negligence claim. Read the transcript that was specifically argued by plaintiff's counsel below.
Yes, Your Honor.
In fact, plaintiff's counsel below, credit, conceded liability, that summary judgment was appropriate on count one, So, but let's talk about count 3 and the direct negligence and this whole installation of the flooring. And so if we accept the argument that your client is making and that it wasn't out of bounds or unreasonable to address transitory substance, et cetera. But what about this? Do you agree that count 3, at least in part, uses direct negligence language in terms of install, construct, and with respect to the flooring by the franchisor?
Your Honor, no, and here is why. Paragraph 14 contains very specific language about construction, maintenance, and upkeep. It's not or, it's not construction or maintenance, construction or upkeep, it's all together. This specifically alleges that there is an ongoing duty, construct, maintain, and keep the premises safe. As worded, as phrased by the plaintiff, by super attorneys in count 3, as phrased, this specifically asserts an ongoing duty by Zaxby's to maintain these premises.
But how can the word construct be construed in a way to talk to an ongoing obligation? Isn't that sort of, you construct it and you're done? So either that was negligent or it wasn't, that's a different issue, but isn't that a separate term? I mean, couldn't the judge order, doesn't the rule provide for the trial judge to award summary judgment in part? For example, I mean, it seems to me that's what the order does at a minimum. Because I agreed with your client's argument as to any maintenance keep, any maintenance provide. But what about the install and the construct? Why is your client entitled to summary judgment as to that?
I will go ahead and mention this first. There is a list of possible materials that the franchisee can use when it constructs the building. It was not constructed by Zaxby's. It was constructed by the franchisee, meeting certain specifications which were set forth by Zaxby's. There was a list of possible materials that could be used. The franchisee gets to choose which of those materials it decides to use. There are several different tile options. In the kitchens, there are highly specific options or requirements, but certainly within the restaurant, there are more options than that. However, construct, again, this is not constructed or when the building was constructed, Zaxby's X, Y, or Z. It very specifically is an ongoing construct. I would suggest to the court that suggests that there is an ongoing duty to replace these materials as needed. While that may be the case, that is not something that was raised by the lower tribunal by any of the parties. And so I don't think that would be something that we can substantively discuss here today, beyond the fact that it is, as phrased, an ongoing duty. Construct, maintain, and keep. Not or, there's not a specific allegation only with regard to the construction. It's one paragraph that has all of them simultaneously and ongoing.
Let me ask you this, Mr. Bog. Isn't it possible, put aside all the specific facts of this case, is it possible in a slip and fall case that both the flooring surface and a foreign substance can be proximate causes of the same slip and fall?
I would agree that would be possible.
And so when it comes to there is an expert affidavit here that concludes that all of the above contributed to Ms. Mayfield's slip and fall. It was the flooring surface and it was the substance on the surface. Why does that not create at least a jury issue that should foreclose summary judgment, given that it was not refuted by the defendant in this case?
Your Honor, at the time that the court entered summary judgment, the new standard was in place. As the court well knows, the Supreme Court specifically stated that under the new rule, when opposing parties tell two different stories, one of which is blatantly contradicted on the record so that no reasonable jury could believe it, a court should not adopt that version of events for the purposes of ruling on that motion for summary judgment. It is our position that the evidence is really quite clear with regard to all of the recipient witnesses, including Tamala Mayfield, who testified for 4 hours that what caused her to fall was the transitory substance. She made no mention of the flooring, despite the fact that she had been to that restaurant, as she testified 2 or 3 prior times, and had walked around the restaurant on that particular day. She was very specific. I slipped because of the grease, which she presumed was due to a nearby broom. Her daughters testified about the grease. The other recipient witnesses who were non-parties all testified about the grease. This affidavit was only presented 1 month, roughly, before the summary judgment hearing. At that point, the case had been ongoing approximately 5 years, I believe. And it's really just an end run around the summary judgment issue. The court is not required to look at this affidavit and say, well, I will ignore all of the evidence currently on the record with regard to what caused her to fall. And all of the recipient witnesses agree, including the plaintiff, that it was the grease.
Is it really inconsistent for the expert to say it was the grease and the flooring surface? In other words, isn't it possible for a plaintiff to think that what she fell on was a substance on the floor, but then later through discovery to find out not only that, but the floor is also substandard? Are those things really inconsistent to say that it was the grease and it was the flooring? I don't think, or correct me if I'm wrong, I don't think the plaintiff has to prove it was only the flooring or only the grease to bring, this case against Zaxby's.
A plaintiff does not have to prove that there was one and only one reason, or that there were two or only two reasons, or three or only three reasons. However, I would suggest to the court that in this case, all of the evidence is that she slipped and fell on the grease. There is no testimony from any of the recipient witnesses that any other part of the flooring was problematic. The only evidence with regard to the actual fall by the individuals who were involved and who were there at the time that it occurred was that the grease caused the issue, not that there was any issue with regard to the rest of the flooring. We did mention this particular test was done approximately 5.5 years after the incident. I would suggest to the court again, the recipient witnesses and the Smithfield were clear.
The Henry affidavit refers to a Stevenson test, Stevenson being the person who actually performed the testing.
Correct. Another person performed it.
Is that Stevenson report in the record, or was it before the trial court?
Your Honor, to be perfectly frank, I cannot recall whether or not the Stevenson report itself was on the record. What I do know is that it was not attached to the materials, if I'm remembering right. It was not attached to the materials that were presented to the court at the time of the hearing. I believe it was simply the affidavit that was attached and presented as evidence at the summary judgment hearing.
Can you address the preservation issue and whether a motion for rehearing needed to be filed given the date of the rule amendment?
Yes, Your Honor. I presume that since we had oral argument granted that the court was not going to want to address a particular issue. But prior to the rule change, case law was very clear that if there was an error in an order granting final summary judgment, that it should have been brought, or rather an order granting summary judgment, that it should have been brought to the court's attention. And we cite the cases extensively in our brief. Case law was clear. If there is an error, you need to bring it to the court's attention. Your Honor, here are all the reasons why the order you entered is incorrect, and give the trial court an opportunity to correct itself. The rule was actually changed to match the case law in that regard, not the other way around. So I would certainly posit that to the extent that there was no motion for rehearing, that has actually been waived.
So the date of the rule amendment really doesn't matter because it was conforming with the case law.
That is our position. The case law had already required a motion for rehearing. It is simply now codified in the rule. Does the court have any additional issues it would like for me to address? No. All right, thank you, Your Honor.
Thank you. You have 1 minute exactly.
Thank you, Your Honor. Just very briefly, I did want to point out, as we've discussed, Zaxby's did not produce an expert affidavit or take the deposition or produce any sort of evidence to refute Tamala Mayfield's expert affidavit. So to all of these questions, it did create an issue, a genuine dispute of fact that must be submitted to the trier of fact. Counsel cannot come up here now on appeal and say, but, it wasn't enough, or, but it was insufficient. Below the affidavit, the only thing that was discussed about the affidavit by Zaxby's was that the affidavit went to the slipperiness of the tiles. They didn't move for summary judgment on the basis that there was not a duty. Any defects in our complaint could be amended. We're a liberal pleading state, and it doesn't go to the substantive merits that Tamala Mayfield produced enough evidence to submit to the trier of fact that Zaxby's had a duty of care to the general public.
You brought up the amendment. I see in the record there was an attempt to amend the complaint, but the only document relating to that was a reply in support of amendment, and then an order denying the amendment. Does that attempted amendment matter? I mean, you just said that the plaintiff could have amended, but it seems like that was attempted and it failed.
Your Honor, it's not part of the record. So again, I'm going to
Fair enough. I understand
unfortunately
it's
not discuss it, but we did attempt to amend it for other reasons. The trial court denied it. Again, those issues were not raised below. On appeal, we're looking at whether the trial court erred in granting summary judgment based without regard to count 3. And to Judge White's point, in part, at the very least, we have a direct negligence cause of action brought against Zaxby's that should proceed to a trier of fact. We can't just stand up here and ignore that part of our complaint and thwart our ability to proceed to a trial. We're stopping Tamala Mayfield from going to court because we use the word "and." We have a direct negligence case that nobody has addressed below. And for those reasons, we ask that this court reverse summary judgment and find in favor of Tamala Mayfield. Thank you. Thank you, Your Honor.
Thank you. This court is adjourned.